matter coming before the court this morning is the state of Ohio versus Linder. As you both know, you each will have 15 minutes to present oral argument. The appellant proceeds first and may reserve up to 5 minutes for rebuttal. We have read the briefs and are ready to move on.
Very good. Thank you very much. Good morning, Your Honors. My name is Jeff James, and I was appointed to represent Kyle Linder in this case. I would like to reserve 3 minutes. I'm not sure that it's going to be necessary, but I will just go ahead for the record and reserve 3 minutes.
Okay.
This is not a complex case. It is really factual driven. I think the court is well aware. This is an appeal on a sole issue, and that is an appeal of a denial of a motion to suppress. Evidentiary hearing was held in the common pleas court, and the judge at that point ruled that the evidence was not going to be suppressed, thus leading ultimately to a plea of no contest in this appeal. As the court is aware, a review of a motion to suppress is a combination of law and fact. You, of course, take the facts as they are, and any dispute of the facts are dependent upon what the court found, unless it's not at all credible. And, of course, the review of the law is to know. With that being said, I don't think this is an earth-shattering case with regard to law. We all recognize the fact that under certain circumstances, the police, under exigent circumstances, may enter into a home without a warrant. The issue in this case is really factually driven, and that is, did the facts under these circumstances, as presented and as put forth in the evidentiary hearing, did they support a finding that there were exigent circumstances warranting a warrantless search or entry into the home? I would like to point out, and I'd be happy to go over the facts, but I think you've already read the facts. There is an error in the applicant's brief with regard to the facts. This was all a situation in which a father was concerned about the welfare. John Schwab was concerned about the welfare of his daughter, Megan Bassett, contacted the Akron police, and ultimately, after conversations and a triangulation of her phone, were able to locate the fact that she was somewhere in the vicinity of this resident on North Howard Street. Finding her car there, that's what led them to believe that this is the house that she may be located at, and that's, of course, been set up the process of going to that home. On page 3 of the applicant's brief, they talk about the fact that Officer Hackathorn approached the door, an unknown male opened the door. That's not actually correct. Officer Hackathorn testified that he took up a perimeter position at the back corner of the house, while his partner was out at the front of the house. And while he was at the back corner of the house, the side door opened, a male started to exit, not Kyle Linder, there was another male in the home. A male started to exit, they made eye contact, and the male immediately returned into the house, closing the door. Officer Hackathorn did say he yelled out, "Stop, police," but he could not say, based upon how quickly the door opened, the contact made, and did not even exit through the threshold of the door, this person exiting the house, or opening the door, whether he, of course, even was aware of that or heard him make that command. So that's a bit of an error in the fact that no one did go up to the house and knock at the house, which is the concern in this case.
But to say that the officer approached the house is not the same as saying that he went and knocked on the door and then somebody responded. I'm not sure that...
Well, it's just that they said Officer Hackathorn approached the door on page 3 of the applicant's brief. He didn't approach the door. He took up a perimeter position at the back corner, saw the door open. A little bit of different. I would like to see him at the door. That was our whole issue, is that why didn't you just go to the door and knock on the door and ask about the welfare of Megan?
Let me ask you a question. Is Megan a minor?
No.
How old is Megan?
She was in her late teens.
Late teens?
Yeah, she was not a minor. She was an adult. And there were at least three other people in the home. There was Kyle Linder, his girlfriend, and the male who tried to exit the door. And there was, of course, then Megan Bassett. Initially, when they made entry into it, I believe the testimony was that, which really wasn't relevant to the brief because they were already in the home at that point. Kyle Linder had said something about, well, get out of here, she's not even here. And at that point, that's when his girlfriend said, no, she's here, she's up on the 3rd floor. At that point, they took everyone out of the house, they made a protective sweep, floor by floor, working their way to the attic, where they found Megan Bassett hiding. And then, of course, they took Megan Bassett, they found that she had warrants outstanding, I think they're a misdemeanor warrant that wasn't really relevant. They took her into custody. They had EMS come to check her out based upon the fact that her father presented that he was concerned about her welfare. EMS came, checked her out, found that there was nothing wrong with her, and basically released her to the custody of the police, who then contacted, I think, Cuyahoga Falls or Stowe. Cuyahoga Falls and said, come pick her up on your warrants, and she was transported to Stowe Municipal Court. That's really not relevant to the issue in this case.
So what is relevant is what did the police know at the time that they approached the house?
They knew that
the father had said that she contacted him and said she was suicidal, that she was a heroin user, she tried to harm herself in the past.
Well, I don't know that she said all those things. The father relayed to the officers that he had contacted his daughter that morning. He was concerned that she was suicidal, and that he did acknowledge that she was a heroin user.
Right.
Correct.
That's what I'm saying, that
That's
police had that information.
That's the information that they had.
Now, did they also have information from some other person who had reported to the father having seen her in the area earlier that day, something about a gas station or gas can?
No, well, I believe that he had contacted her on the phone and had made arrangements to meet her in the parking lot of the hospital.
Right.
And I have to double check on that. There may have been something about seeing her car that really didn't have, I didn't see that as being that relevant to the issue of what the police knew at the time they approached the house on North Howard. So what we are aware of is that they were called and they were simply told that, I have concerns about my daughter. I think she may be suicidal. She is a drug user, and she was supposed to meet me and has failed to do so, and I have concerns. And based upon everything, then they did locate a possible residence where she may be located, and they at that point set up a perimeter, and everything, of course, transpired. The issue, very simply,
It seems to me there was also some information that that house was a drug house, or
they had information from the, which of course just
Sergeant.
from the sergeant in the police. I think it was during call day. There was just at some point there was information relayed in one of the call days that there was concern that there was drug activity at that house. That's correct, drug use at that house. So that's the information that they had at that point, upon which they approached the house. The thing is that we can go through lots of different cases, and I'm not going to here and try to argue that somehow we should not, or that we should somehow set aside the exigent circumstance basis for warrantless entry into a home. I think that's pretty well established. The state cites numerous cases, but they're all distinguishable. Right? I mean, that's the issue, is that how are they distinguishable? You have cases where I went to a house, all right, such as Champo, State versus Champo, the state relies upon. Well, that was where there was a call of a domestic dispute. They went to the house, and they met the wife and the daughter at the door crying, visibly upset, and the wife was holding the door open. And the police went on in, and the father or the husband is saying, get out of here. Well, that's a little bit different than this case. We have State versus Wyatt. Well, that was a case where they were placing a man under arrest, and he said, I'm concerned about my children, who are at home, who, because you're arresting me, are now unsupervised. Well, surely we have an interest in protecting children, particularly if they're unsupervised, and so that led to the ultimately entry into the home in State versus Wyatt, which of course was a 9th District case. Those are all distinguishable from this case. This is a case.
If we take the facts that the police knew that the father suspected the daughter of being suicidal, doesn't that raise the level of concern on behalf of the police and creating an exigent circumstance once they identify her car there in the backyard?
And that's the point of exigent circumstances. It's all a matter of degree or level. Does that raise a concern? Yes. Are we concerned about welfare of people? Of course we are. Do I go to the house to check on her welfare? Yes. Would I go up there and knock on the door as a reasonable police officer or a reasonable person? Is Megan Bassett here? Is she okay? We'd like to talk to her. None of that was done. This was a forcible entry based upon nothing more than the statement from a father that I'm concerned about the welfare of my daughter. And as it turned out, apparently she wasn't suicidal. Apparently she was not in need of any medical attention because she was actually taken into custody and transported to Stowe Municipal Court for her appearance.
Isn't there some testimony that this particular location was known to the police as having drug activity?
Yes. Yes, there was, in a call day, there was information that this address, there, and I ask you to take that kind of with a grain of salt. You know, sometimes I get and have gotten upset for years with the appellate courts with the idea of pretextual stops. Because you talk about the fact that, well, we're not going to look at what the pretext was. If there was a legitimate basis, that's all we're going to look at. And I have problems with that.
Well,
And this-
only that it speaks to the information that they also had, that she had a problem with drugs. In other words, in this specific instance, only that it speaks to the totality of what was in the police officer's knowledge at the time as it related to this particular person that they were doing welfare on. I understand that doesn't speak to it would have been reasonable to knock first, but it is an additional factor that they had.
It is, but I guess what I'd ask you to do is actually consider that it's a little bit different than the normal, like, pretextual stop. That may have been actually more of a reason as to why I wanted to get in this house, and I was going to use any reason to get in that house, because I had that information. A little bit different, because surely I think what he did to get in this house is unreasonable. You're there for a welfare, knock on the door.
The flip side of that is that we often hear, and I don't know if you'll see this in the transcript, but we often hear officers testify that when they approach houses that are known for drug activity, that there are typically weapons involved. And so there may have been concerns about, just knocking and announcing themselves. It might not have been present in other circumstances.
Well, and that surely we see that in search warrants all the time. Typically, that's when you're looking at trafficking. I don't think there was any information here that this is a house that there was trafficking going on or there was sales going on. There was information that there was a house that was kind of a flop house that drug use with activity was going on.
And you've reached your
Very
2
good.
minutes if you want to.
Yes, thank you very much.
Counsel, you have 15 minutes.
Thank you, Your Honors. May it please the Court, Counsel. My name is Qasim Ahmed, and I represent the state of Ohio in this matter. As Counsel expressed to the Court, the crux of this case is the exigent circumstances. Certainly, the one case that I would really like to point this Court to is the 9th District case. It was in 2004, and that was statewide, which Counsel alluded to previously. That opinion was authored by Judge Slavey. Judge Moore, you concurred on that case. And the main holding of that, it dealt with exigent circumstances and when they existed. And when there's a necessity for immediate action that will protect or preserve life to avoid serious injury or worse, that will override certainly an individual's constitutional right of privacy. When we look at this case, I think we need to view it, as the Court alluded to, what the officer knew at the time, looking at the totality of the circumstances, and were his actions reasonable under the circumstances. Certainly, knocking on a door would be appropriate if you didn't know lots of the facts that were known in this case. First of all, Megan Bassett, who was in her early 20s, had been a heroin addict, and this Court, I'm sure, is aware of the heroin epidemic that's going on right now. Just in the city of Akron alone, not just Summit County, but we have 1.5 EMS runs for overdoses a day.
But Attorney Ahmed, you said that she's in her early 20s.
Yes, Your Honor.
Her father, did he have guardianship of her?
He did not.
Well, how can you equate unattended children in a home, minor children, with an early 20-year-old woman, even if she's a drug addict? How can you equate the two?
Because a person's life is at risk in this case. Certainly, there is a difference between.
There's allegations that her life is at risk.
Yes.
No risk, she's not standing on a bridge ready to jump.
Yes, Your Honor, that's absolutely correct. But due to her drug history, due to her past suicidal ideation, due to her immediate expression of that suicidal ideation that day to her father, the fact that she was scared and wanted him to meet her at the hospital, she didn't show up. He's out looking for her. Her phone is triangulated, and it's found to be at a known drug location, not in front of the house on the street, but in the backyard. Certainly, all of those items taken together did elevate that to make the officer have a reasonable belief that his life or his daughter's life was in danger at that point.
Elevated but exigent?
I believe so, Your Honor. Due to the nature, if it was a different drug even, if it was marijuana, something where there's not a high risk of overdose or death, I believe we'd have a totally different analysis of it. But due to the fact that someone could expire rather quickly, and due to the fact that there was some concealment there, I believe there was a reasonable thought process that her life was in danger at that point.
When you say concealment, are you referring to the individual who came to the door and then closed it?
That as well, Your Honor. I was initially focused on the vehicle that was concealed in the backyard, but however, and when I said in my brief that the officer Hackthorne approached the door, that ultimately was his goal, was to make contact with the occupants of the home. So he was approaching it, whether he was knocking at the door, it wasn't that. But to go back to your question, it could be viewed as a furtive movement. The fact that the male opened the door, saw police, and immediately slammed the door. So I think at that point, that would also add to that concealment as well.
When you say concealed, was the car in a garage, was it under a tent? How was it unseeable from the street?
It was parked behind the home.
In a driveway?
No, there was a driveway, but my understanding, and the record is not 100% clear, but that it was parked behind the home in the backyard. That's what appears in the record. That was my understanding, Your Honor. I did not handle the case at the trial level. It was unclear. I apologize for not having that information.
Was there any testimony from either of the officers that they were concerned that this young woman was being held against her will?
No, Your Honor. That was never a concern. But with her suicidal ideation, you made reference, you asked a question, both you and Judge Hensel, about the fact that it was a known drug house. Then I believe you made reference, Judge Moore, to the fact that guns are often there. The heroin that could be in that house is just as dangerous. I believe that would be an instrumentality that she could use, being the fact that she is a heroin user and is suicidal. It was very conceivable that she could use that instead of a weapon to also harm herself.
Well, of course, if you take that to its logical extreme, that would dispense with the need for a warrant. Anytime the police find themselves at a known drug house, they could just go in and kick down the door and say, well, heroin, is being sold here. Somebody could use it and overdose. And I don't think that the Constitution would permit that.
I agree with you, Your Honor. I don't believe that would be the case. But again, looking at the totality of the circumstances, I believe in this case it would definitely be distinguishable from the police officers using that sole fact alone to enter someone's home. When we look at another 9th District case, State v. I believe it's Chiampo, Chiampo. That case talks about the right of police to enter and investigate an emergency without the accompanying intent to either search or arrest, and how that is inherent in their very nature or their role of being a police officer, to prevent crime, to preserve peace, to protect people. We also need to focus on what was the police officer's intent being there. The police officer wasn't there to investigate a crime. The police officer wasn't there to collect evidence. The police officer was there for a welfare check. this isn't some sort of police-created exigency. This was something that the police were called out to. This was something that was corroborated by many of the facts, including some of the facts we discussed, with the car being in the backyard, with her phone being triangulated to that area, with the fact that somebody slams the door as their immediate response when a police officer shows up. All those facts taken together did create the exigency and a reasonable belief in Officer Hackathorn's mind that he did need to act immediately, and he did not have the time to get a warrant. At that point, something worse, an overdose or death maybe, could have occurred.
What about the proposition that opposing counsel makes that could have knocked on the door and just inquired, is she here, is she okay? Do we have your permission to come in?
Your Honor, I do believe that could have occurred, but I believe that the correct, or the approach we should be looking at is not what could the officer have done differently, but armed with the knowledge and information that he had at the time, did he reasonably react? We don't know, and it's unclear from the record that the officer never made it to the door. Prior to making it to the door, we have this male open the door, see the police officer. I believe there was some colorful language used at that point, and he immediately slams the door. That immediately elevates the exigency at that point.
Was there any testimony as to what happened at the front of the house? In other words, as I understand, when the officers arrived, one of the officers went to the front of the house, the other one did the sort of perimeter check and went to the rear. Was there any testimony that before the door opened on the side, that the officer in the front knocked or, somehow announced that the police were there, or that anything happened?
There was testimony that dealt with that. The officer that was in the front, his role was more of a lookout or a backup role. He was there to more or less keep an eye on things. Officer Hackathorn was the lead officer. He was the one that was the main actor, and the secondary officer was there to be just that, the secondary officer, in case anything else occurred.
There was no intent to knock on the door ever?
No, Your Honor. It's unclear from the record. I believe they were approaching the house to make contact, not to just kick the door open, but prior to them being able to do that, the unknown male at the time opened the door and slammed the door upon seeing police. So we never made it to that point. And there was no testimony of whether he was going to just walk up to the door and knock and announce. I believe there was a question posed by counsel saying, why didn't you just do that? But I don't believe that his response was, I was never going to knock on the door.
But you just said that when she asked about the front yard, you said he was just there. Hackathorn, who was in the backyard, was the lead guy. This guy was just there as sort of a lookout in the front yard. So you made it sound like he never had any intent to go up and knock on the front door.
No, when officers approached, I believe he was getting a look or a lay of the land to see possible exits. For police safety as well, he needs to kind of know what he's approaching. And a lot of times, I think there was testimony to the effect that a lot of these homes do not use their front door as their main door. A lot of times, police officers approach the side door when making contact with these homes. Your Honor, unless if there are any further questions, I'm prepared to conclude at this point. Again, Your Honor, we need to look at the officer's actions in this case, looking at the totality of the circumstances and what was known to the officer at the time. And when examining what was known, we need to determine whether his responses were reasonable in this case. And Your Honor, I would propose to this court that they were necessary and were needed to protect or preserve life or avoid a serious injury. Again, the officer's purpose was a response to an emergency situation, not for the apprehension of crime and not to search for evidence of a crime. Thank you, Your Honor.
Thank you.
I'll be very brief.
Mr. James?
Your Honor, just so that you're aware of the facts, I mean, in this case, Officer Hackathorn testified that upon arriving at the house, Officer Hackathorn told his partner to go, this is quote, to go to the front but the house was not, to go to the front and watch. He proceeded to the back of the house, is his testimony, the transcript at page 11 and 12. To the back of the house to set up a perimeter. On the back of the house, he could hear movement and voices coming from inside the house, although nothing was discernible. It wasn't like they were screaming or anything of that sort. I think he actually addressed that. It was just voices that he heard emanating from the house and movement, as you would if you were standing next to anyone's house. After about 10 or 15 seconds, he said he first heard and then observed the side door opening. A man stuck his head outside and looked around. When the man saw Officer Hackathorn at the corner of the house, the officers yelled, "Hey, don't move," and whereupon the man quickly turned back in the house and shut the door. At that point, Officer Hackathorn went to the side door, tried to open the door to make entry, did knock, tried to open the door to make entry, finding that the door was locked, kicked the door in and went on inside. Your honors, you'll do with this what you think is appropriate. Do I have concerns? Yes. I mean, yes, I want exigent circumstances. We all want to preserve life. We always want to preserve safety. Yes, there's no question that those are paramount interests of us and the police. But the fact is that how far do we go? At what point do we say, look, we've expanded this to the point that we're actually now affecting, fundamental rights. The right to be in my home, uninterrupted. Knock on the door. Just ask, is she here? Is she okay? That's my concern in this case. If we empower them to make the decision that I, in my own mind, believe that there was an exigent circumstances which warranted this based upon some hearsay, some statement about some other adult, well, what's going to stop that from just being escalating, to what degree? So that's my concern. Thank you very much for your time.
Thank you. Thank you both for your presentations. Court will take the matter under advisement to issue an opinion, which will be sent to both parties, and you can certainly check the Supreme Court website. Have a good day.
Thank you, Your Honors.
Thank you, Your Honors.